Is this working?
Good afternoon. Good afternoon. I never was able to get that whistle, that loud whistle. I need it now. Good afternoon. Thank you for joining us for lunch. Welcome to those of you watching via the live stream. My name is Nate Kazmarek. I am Vice President and Director of the Practice Groups. I'd like to thank the Federalist Society staff for their efforts in pulling together today's 10th annual conference. Our gratitude as well to the Federalism and Separation of Powers Practice Group, who helped arrange the luncheon panel, which we are about to enjoy, titled Administrative State on the Brink? Question mark. We've got an excellent conversation teed up and a moderator who is certainly well suited to it in the Honorable Judge Naomi Rao. Judge Rao was appointed to the United States Court of Appeals for the District of Columbia in March 2019. She is a graduate of Yale and the University of Chicago Law School. She has served on all three branches, including clerking for Justice Clarence Thomas, working as counsel for the U.S. Senate Committee on the Judiciary, and as a special assistant associate White House counsel for President George W. Bush, and later, of course, as the administrator of OIRA. For 11 years, she taught as a law professor at the Antonin Scalia Law School at George Mason University, and in 2014, she founded the Center for the Study of the Administrative State. We've been fortunate over the years to have her join our programs on several occasions, and it's certainly safe to say that we've always learned a great deal from her as a result. So please join me in welcoming Judge Rao and our wonderful panel.
Great, thanks so much, Nate. It is really a pleasure to be here at the 10th Annual Executive Branch Review Conference. I can't believe, Dean, that it's been 10 years that this has been going on. It's an event I certainly look forward to every year, and so it's great to be here, and I'm very happy to be moderating this panel with two friends and excellent colleagues. So today we're going to be discussing on this panel this question, is the administrative state on the brink? And that made me think, what exactly are we on the brink of? I think there was some suggestion in the panel description, maybe we're on the brink of the Supreme Court cutting back on the delegation doctrine or minimizing judicial deference or something like that. So maybe that's one brink. I think from recent developments, another brink might be that perhaps the administrative state is going to simply dominate all of our social and economic life. That could be another brink that we are at. But in any event, to discuss the topic, we have two leading experts, and I'll just give them a brief introduction. We have Sally Katzen, who is professor at NYU Law School, where she focuses on administrative law and regulation. She's served in numerous positions in the government, including, most importantly, in my view, as administrator of OIRA, i.e. the regulatory czar. She had that position in the Clinton administration. And I'd just like to note that Sally is primarily responsible for the content of Executive Order 12866, which governs regulatory review and has really been kind of a seminal document setting out the principles of what good regulatory practice should look like. And that EO, unlike many EOs, continues in effect today. And then we'll be hearing from Philip Hamburger, who is professor of law at Columbia Law School. He is one of the nation's preeminent scholars of administrative law and many other topics. He has argued in numerous books and articles that the administrative state is unconstitutional and a serious threat to our civil liberties. He's also put much of his scholarly work into practice. He established a Center for Law and Liberty at Columbia Law School, and he also founded the New Civil Liberties Alliance, which is a nonprofit public interest law firm in Washington, D.C. I think we're really lucky to have such an interesting duo to discuss the question before us. And so we'll have some opening remarks from each of our panelists and then a moderated discussion. We'll be opening up the mic for audience questions, as we go along. So let me turn it then over to Philip to get us started.
Thank you. It's a great pleasure. Oops, I need this, don't I? It's a great pleasure to be here, and the knowledge assembled in this room is far greater than you would find on any faculty in the United States, perhaps all of them put together. So it really is an honor to be here. Change. Change is inevitable. It's generally inevitable, and it's certainly inevitable for the administrative state. And for many of us in this room, that's not a bad thing, because we are on the side of change. We're often told, don't fixate on the Constitution, because change is inevitable. Well, what goes around comes around. Change is also coming for the administrative state. You could view this talk as being about the living Constitution for the administrative state. And I think there are both practical and principled reasons why the administrative state is going to undergo some change. How and exactly when, I don't want to speculate on. I hope this term, if not this term, the next, and so forth. But it is coming. And it's important to understand why it's coming, why it's beyond the control of any one justice or any one academic or other scholar, because only then can we see what sort of changes will be necessary, where the pressures will be. So let me focus at first on the practical reasons. The administrative state now increasingly affects individuals, no longer just corporations. Now individuals are bossed around in the way that used to be commonplace only for corporations, not the individuals. Examples, well, Obamacare, bump stocks, COVID regulations, especially vaccine mandates, all of this make us feel that power as individuals, not merely third-party observers watching it happen to corporations. Another reason why I think change is inevitable is the increasing diversity of the nation. Federal administrative power developed to evade the nation's diversity. Woodrow Wilson was very candid about this. He worried that progressives, such as himself, could not persuade a diverse public. That progressives need to influence, and forgive me, I'm going to quote language that's disagreeable. It's his language, not mine. He said that we, meaning him and his friends, need to influence the mind not of Americans of the older stocks only, but also of Irishmen, of Germans, of Negroes. And he said, again, this is a quotation, it was difficult to influence, he complained, the minds cast in every mold of race. So you understand what he was saying. So he and his fellow progressives therefore try to shift legislative power out of Congress into the hands of people, well, like themselves. In other words, they're trying to avoid diversity and establish a homogeneous set of lawmakers, educated upper crust types like themselves. Well, that sort of racism no longer pervades the administrative state. But the administrative state is still a means of circumventing the diverse tastes of a diverse nation, and that cannot stand. That just inexorably is not going to be plausible. Yet another problem, practical problem with the administrative state is that it elevates expertise over science. The two are very different. There's a tremendous attempt for the last 100 years to assimilate the two. Expertise is practical science. Science really is expertise. Not really. And by the way, I got into all of this, you should know, not because of some predetermined animus against the administrative state, but because of science, because my friends were being censored. The administrative state crushes science. So I care about this in particular. Regulatory expertise is knowledge that is settled enough to justify regulation, right? It consists of known answers to regulatory problems. That's the authority of regulators. Cutting-edge science is the opposite. It involves questions about the unknown. Science has no fixed truths. It's about showing error, unsettling theories, and disestablishing truths. If you're in any way knowledgeable about the literature on science in the past century, you'll know that there's a debate about exactly what science is, and Karl Popper, as well as some of his critics, recognize that the only thing we can really know is proof of error, not of truth. And that should be illuminating about the administrative state. The implications are that expertise tends to be out-of-date science. But bureaucrats need expertise because that's what gives them authority. Yes, their authority comes from an act of Congress, but the real underlying authority comes from the claim of knowledge, of expertise. And so they tend to elevate expertise over science. And by imposing expertise, they usually impede science and science-based businesses. This has long been evident, just to name a few agencies, from the FDA, right? It's also evident, and this is where I got into this, from HHS, and in particular, its use of IRBs to regulate academic inquiry. It's a lethal thing when you suppress scientific and medical knowledge. And then, of course, there's the sheer arrogance of the administrative state, an arrogance that even reaches above the law. Just to take one example, the CDC defied the Supreme Court precedent, recent Supreme Court precedent, to extend the mortgage moratorium. As put by Maxine Waters, who's going to stop them? Who's going to penalize them? One can only imagine what the justices, especially Justice Kavanaugh, thought about that. And then there's political conflict. We're all painfully aware that political conflicts have become rather intense, ugly, disconcertingly so. The administrative state is said to avoid political conflict. It was said to be all about taking issues out of the realm of politics, that nasty area, dirty area, put in the hands of bureaucrats who are above politics. But actually, it has intensified political conflict. I don't want to put all the blame on the administrative state, but it has a lot of the blame to bear. Power in this country once rested on widely distributed elections, state and federal elections, and different House and Senate elections, many, many elections of many, many different people. But policy is now centralized in the federal government, and it is concentrated in the bureaucracy. So vast power now rests on presidential elections, not the election of representatives, state or federal. And that means that the contest over power, through the contest over the presidency, is an all or nothing battle. Politics, therefore, necessarily becomes warfare because everything rests on one election. And this is significantly, even if not entirely, the fault of the administrative state. And then the last of, I'm sure there are many more practical reasons why this change is inevitable, but I'll mention one more, which is alienation. Alienation is growing in this country, particularly from government. But it's not so much against the United States. It's alienation, in particular, against that amorphous sort of US government, which isn't really its government, the administrative state. Against unelected, autocratic, arrogant, and unaccountable control. Many people don't clearly differentiate between the administrative state and the constitutional government, but to the extent they do, it's the administrative state that's the problem. The representative lawmaking has many virtues, but one of them is it's designed to secure buy-in from the public. When the public get to participate, they feel included. It's what Albert Hirschman called voice. Right? If you run a firm, you want everyone to have voice, even if they don't win. The administrative state is designed to evade not only consent, but also voice. Yes, you get notice and comment, but as Justice Kagan said, that's just a charade. So administrative power is inevitably alienating. And the nation, I think, as we all know, can no longer afford this sort of alienation. So change needs to be coming. I want to close by moving away from the practicalities to the principled reasons for change. And in fact, I just want to focus on one. I'm sure there are others. But the main one, the one that really needs emphasis, is that the administrative state is a civil rights problem. Now, this is a new vision of the danger. The old vision was about separation of powers. But administrative power is also a threat to civil liberties. I think it is actually currently the leading threat to civil liberties. And I want to give just two examples. There are many, many more. And the two examples, of course, are ones that are on the plate of the Supreme Court. First, delegation doctrine. The non-delegation doctrine. The non-delegation doctrine is a civil rights issue. Yes, it is a separation of powers problem. It shifts legislative power to the executive. But it's also a voting rights problem. It dilutes voting rights. Administrative power takes power out of the hands of the voters. Oh yes, we can still vote, but we don't elect our most active lawmakers. It dilutes or diminishes the significance of those votes. This is wholesale dilution of voting rights. Now, of course, we mostly pay attention to the retail dilution of voting rights, and we all care about that and should. But administrative power is a wholesale dilution of voting rights, and we need to care about that. It's exceptionally dangerous. And then there's the problem of judicial deference. Deference also is a threat to constitutional rights. Separation of powers is involved, yes, it does involve, again, the shift of lawmaking to agencies, but it's also a due process problem. Traditionally, people thought about deference in terms of the relationship of a court to the legislature. But what one has to think about is what's happening in a courtroom in a particular case. And in cases, it alters the relationship of a judge to the parties. It requires judges to be biased to one of the parties, the largest and most powerful parties, and against all other parties. This is systematic judicial bias required by Supreme Court precedent. It's a flagrant denial of due process, perhaps one of the most persistent in our nation. So I think the civil rights problem cannot be ignored. It is central. So just to sum up, I think both practical and principled reasons lead me to think that change has to come. If it doesn't come, we're going to see a lot of other problems that may be greater than the administrative state. And my feeling is the Supreme Court gets this too. Will they act this year? Will they act next year? I don't like, what is the old joke? Predictions are difficult, especially about the future. So I'm not going to go down that line. But the sooner we get change, the better, because this is just too dangerous. Thank you.
Well, good afternoon, and it's a pleasure to be here. I think it was my idea that Phil go first. And that was unfortunate because he's so knowledgeable and erudite and persuasive. A hard act to follow, but I do see things differently than he does. I agree with his prediction, change is coming, but I see it coming in ways that I think will not make us all happy campers. I'm going to leave the generalizations to the end and focus on some of the specific changes that I see coming. And I'll start where he was talking about the non-delegation doctrine. And this has been something that the court has grappled with for over 200 years. Now, I will acknowledge that Article 1 says all legislation. Congress has the power to make all laws, and all generally means all. Though proponents of the non-delegation doctrine, I think, have put a lot of weight on one word, even for devoted textualists. But passing that, how specific did Congress have to be? And the president who signed the bill? Well, Justice Scalia, in a 9-0 decision in 2001 in the Whitman case, said it's okay if they provide an intelligible principle. Now, I want to acknowledge that Justice Thomas wrote a concurring opinion saying, wait a second, intelligible principle is nowhere to be found in the Constitution. True. But Justice Stevens, who also wrote a concurring opinion, said, and nowhere in the Constitution does it say that Congress cannot delegate. I think the latter is useful information, particularly so long as Congress retains the power of oversight and the ultimate power to enact a law changing the delegation. Now, a lot of law reviews articles have been written debating on whether, in fact, there was any delegation at the outset by the first Congress, on the theory that the first Congress consisted of many of the people who were present at the creation of the Constitution, and therefore their interpretation would prevail. I think it might be interesting and useful to know that, but is that really the only question that we would be asking? Now, recall that in 1789 in Philadelphia, we were still 13 struggling former colonies hanging by our fingernails on the eastern seaboard with mostly agrarian interests. I guess I shouldn't have said we, because the decision makers then were mostly men, white Christian men at that. I would argue that more important than 1789 for our present purposes is the present and the future. Because the non-delegation doctrine rests on the proposition that Congress shall make all laws. Congress is having a hard time doing anything. Congress cannot even pass the annual appropriations bills. We have sadly reached the point where people are running for and getting elected to office on a platform of, I will not compromise. I will not agree to anything the other side wants, or most famously, an incoming majority leader of the Senate, my number one agenda is to make sure that the sitting president is not reelected. This hardly bodes well for Congress making decisions of any sort. Actually, this is driven in large part by the political parties, which, to use a quaint phrase from the Federalist Papers, is what Madison was referring to in Federalist 10 of factions. And I think he's right. Dean always enjoys the fact that I cite the Federalist Papers when I'm talking to this group. He should know that I cite the Federalist Papers when I'm talking to other groups as well. Now, the truth of the matter is that many of our politicians are not acting like the statesmen envisioned by the Founding Fathers. Congress is not functioning very well, let alone at the level to resolve the far more complicated and complex issues that are confronting us today compared with those that the first Congress struggled with. So as long as Congress has made the fundamental decisions and given guidance, general as it may be, to those with expertise and experience in the executive branch, we might well continue thriving as a nation. And I would remind you that for over 200 years, at least 100 of which we've been in the arms of the administrative state, we have indeed thrived. But what would it mean if we were to adopt this view of Congress's role and the concomitant constricted view of what the agencies cannot do in this day and age? Now, it may make a difference if the resurrection of the non-delegation doctrine is to send a message to Congress so that in the future, if and when, more if than when, it is able to enact legislation, it will be more specific and answer all possible questions, those apparent and those that even people with clear foresight might not predict. Does that portend far fewer laws? Some would say that's a good thing. Would that be? It's a question for you all to consider, given the fact that we have not stood still. We continue to innovate. We continue to have different types of issues, drones, electric vehicles. Let them run free. That's one option. The other possibility is that by resurrecting the non-delegation doctrine, we are inviting a re-examination of all of the statutes assembled by Scalia in the Whitman case, all of which were held by the then Supreme Court to be fair and well-grounded. And we would now re-examine, and we would now throw out those that say, you shall regulate in the public interest. Oh, it's not clear enough. It's not detailed enough. If we are going to look back at the laws that were enacted in the 30s, 40s, 50s, 60s, you get my point. There's a great deal of uncertainty and a great deal of concern. And since a lot of what we need depends on some confidence and stability, it may be a difficult matter. So let's look at Chevron, which is the other doctrine that Phil talked about, and the cries of outrage that it's an abdication of judicial power by the courts to the executive branch, and, as he said, makes the federal government an even more formidable opponent in litigation against the citizens. I don't see it. I really don't. As you all know, since you're all basically well-schooled in this area, you do not get to the question of deference unless the agency has been granted authority by the Congress to make determinations with the force of law and has issued its interpretation of its authorizing statute in the course of using that authority. You will also recall that you do not get to the question of deference unless Congress did not address the issue or what it said was ambiguous, i.e., step 1 of Chevron. And that decision is a decision made by the court, not the agency. The court decides if Congress provided an answer. And if the court decides that Congress did provide an answer, that's the end of it. There is no delegation, there is no deference to the agencies. And if you get to step 2, so that the agency's interpretation is going to be considered, it has to be reasonable. And who do you think decides whether or not it's reasonable? It's the courts who have to decide that it's reasonable. Now, on the whole, I think if I had to choose for most purposes, between, on the one hand, a dictionary or a series of dictionaries, and on the other hand, an agency which sees not just this phrase or this section, but the context in the act as a whole, indeed sometimes in a series of acts. And that agency has been providing technical advice and assistance to the members of Congress who have been drafting the bill. I think I'd go with the agency. And I would ask each and every one of you, particularly the practicing lawyers, when you're asked for an opinion by a client, do you go straight to the dictionary and stay at the dictionary and never, ever consider anything else? I would doubt that. At least that's not the way I practiced law in my old-fashioned days. So what if the critics do win the battle? As I expect they will. And Chevron is either tightened, like our was with Kaiser. I'm dropping names of cases you all probably are familiar, and if not, I'll be happy to provide cites. Or if Chevron were eliminated altogether. Will we revert to every judge and her dictionary as the deciders of things? Now I would like to read from Madison 37. This is for you, Dean. Madison 37 all new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberations, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. Beside the obscurity arising from the complexity of objects and the imperfections of the human faculties, the medium through which the conceptions of men are conveyed to each other adds a fresh embarrassment. The use of words is to express ideas. Perspicuity, therefore, requires not only that the ideas should be distinctly formed, but that they should be expressed by words distinctly and exclusively appropriate to them. But no language, I'm still quoting, but no language is so copious as to supply words and phrases for every complex idea, or so correct as to not include many equivocally denoting different ideas. I do like the Federalist Papers. This is not a slam at textualism, I would say. It's simply an acknowledgement that it may only get you so far, and you need other aids in determining what a phrase or a word means. In any event, another way to ask the question of what happens with Chevron is overruled. We're no longer deferring to an agency's interpretation. Is what do you think most generalist judges will do? Actually, I'm going to predict, even though I smashed my crystal ball in 2016, I'm going to predict that it will likely be a little bit like what we have with legislative history these days. Legislative history was given a bad name and scorned by some jurists, but it is included in a lot of briefs, and judges and justices read those briefs. They may not be impressed or may wish to unread what they have read, and they've similarly discarded references to the purposes of legislation, but they do get exposed to it. So I suspect that agency interpretations may well be disfavored if Chevron is gone, but not ignored by most judges who will be looking for whatever information they can to help them in their decision-making. On the other point that I just want to raise in terms of Chevron is when you talk about an agency's interpretation of its rules, not all rules are the same. Some are highly technical, some more pedestrian, some relatively insignificant, some really big deals. Recall what Justice Scalia said in Whitman, and I'm quoting, "The degree of agency discretion that is acceptable varies according to the scope of the power congressionally conferred. While Congress need not provide any direction to the EPA regarding the manner in which it is to define county elevators, it must provide substantial guidance on settling air standards that affect the entire national economy." Now, I think Judge Rao will agree with me and confirm that I'm saying that not all rules are the same, and one size does not fit all. The decision with respect to accepting or relying on agency interpretation does not have to be uniform, but it should be informed by the circumstances. In any event, there are lots of other areas that perhaps we will get into, such as appointments, removal, civil service, whatever, but I think for now, I thank you.
Great, thank you both so much. You obviously both come at this from, I think, very different perspectives, so maybe it's a good idea to just let you both respond to what's been said. Philip, maybe you want to say something about some of the practical concerns that Sally has raised in terms of, well, what do we do in a complex society where Congress is unable to do its job?
Thank you, and it was very interesting. Will you forgive me if I actually say, I want to comment on three things. Very quickly, non-delegation, the incompetence of Congress, which I think we can at least agree on, and on Chevron. First, very quickly, as to non-delegation, there's long been a concern that there is no non-delegation doctrine. Cass Sunstein, my former colleague, pointed this out too. But it's actually useful to look at the text. The word all does introduce it very nicely, but then goes on to say, shall not be vested. Now, if it had just said vested, as in all legislative powers are hereby vested, that would transfer the powers but not limit their transfer beyond Congress, right? That's like a conveyance of land, and the recipient can convey it further. But it doesn't do that. It says, shall be vested in. In other words, it doesn't just transfer, it also has a mandatory location for these powers. That's rather revealing. So I think the text actually is more full. But I think we can't just rest it on text. I like text, I'm not a textualist. I think we should look at the full range of issues here, and I think that is to include the racist origins. I don't think we anymore live in a society where we can ignore the racist origins of the administrative state. And nor can we forget the vote-diluting consequences the non-delegation doctrine is currently understood by the court. If people are deprived of the efficacy of their vote across the board, that matters. Now, it's not the same as discriminatory vote dilution. That's bad, and that's in the traditional analysis of vote dilution. But there is a generic vote dilution that's also serious, and that it was based in class prejudice even when it wasn't racist. Second, as to the incompetence of Congress, yes, let's agree on this. Congress is incompetent, but that's not an accident. These are all smart people. They're just paying attention to the wrong things. And that's because they've been infantilized. And the best way to understand this is Judge Rao's scholarship. Judge Rao is the expert on this, right? And it's not an accident that they are incompetent. There's nothing inherent, right? It is based in the structures of the administrative state that allows them to get away with all this stuff. And what legitimizes these structures? The Supreme Court. So I'm inclined to blame not Congress, but the Supreme Court. The Supreme Court has accepted a structure that is not our government. And that is profoundly dangerous, and it does lead to a host of the problems that you discuss. Now, Chevron. Firstly, I just want to put aside the dictionary caricature. I don't think any judge just looks at dictionaries. They're useful, but they're of limited use. It's just one of many considerations. We have a whole canon of construction that we're all familiar with, and how it's used can vary from case to case. But the key point is, when a judge faces an ambiguity, one possibility is just to run to Chevron and say, you, agency, you decide it. Another possibility is for the judge to decide it. There is a third possibility, though, which is very important, which is simply to do nothing. If the ambiguity is so substantial that the canons of construction cannot help you, and if you're unwilling to defer to an agency, there is the possibility of just saying, there is no law here. It doesn't tell me what to do one way or the other. Congress has to fix this. And by the way, I'm not the only one to think of this. I think my friend John McGinnis has discussed this, and Frank Easterbrook has discussed this in very interesting articles. This is a common understanding, and judges have no constitutional duty to decide a case come hell or high water. They can just walk away and say there's no law here. Now, I want to close simply by getting to the judicial bias question, because I think many defenders of the administrative state, particularly Chevron, want to pretend this is not a problem. The awkwardness is this. The logic of Chevron is one of interpretation. Where there's ambiguity, the ambiguity needs to be interpreted, and then it gets shoved over to the agency. You can try to justify Chevron in terms of delegated lawmaking, but the reality is it's an interpretation problem. That's the key logic underlying the case, and interpretation belongs to the judges. That is saying what the law is, and that is peculiarly the province of the Judicial Department. And so I think it's difficult to escape. As an aid to understanding Chevron, though, I brought along something. Hold on. So here we have a judge. This delightful little thing, it's called Doing the Deference, and this is a product of the New Civil Liberties Alliance. And you see, if you give a little push, just like this, just a little bit, you get Skidmore deference, bowing to government in cases, which you shouldn't do. You should be impartial between the two parties, right? A little bit more, you get our deference, and you give a good shove, full Chevron deference, bowing to the executive and the agency. For a suitably generous contribution to the NCLA, you can have one of these too. But what I actually want to give this to you, Sally, as a present. So you can understand the bias involved in Chevron deference. Thank you.
Actually, I would urge you all to go on to, I think YouTube has it, but the students, my students at NYU Law School did a Chevron two-step dance to, and it was before Hamilton, but it was the same idea, and it's really quite funny with all of the kids in the classroom leaping around doing the Chevron two-step. But if you can't find it again, do reach out, and I'd be happy to let you know where it is. Naomi, Judge Rowell, did you have a question?
Yeah, well, I was wondering, Sally, if you could maybe address, you said at one point in your remarks that the Constitution of 1789 was not the one that we should be most concerned with. We should be concerned with thinking about the Constitution for today, for the present, and for the future. And so I guess I'm wondering, what is the purpose of a Constitution if it's not fixed at some time? Like, do you believe that the Constitution contains a non-delegation principle, but that it has come not to matter so much in the present, or that it just doesn't contain such a principle at all?
I think, Judge, you've asked 3 questions.
Oh, maybe. Okay.
Let me.
Well, I'm used to it.
You're used to it, and I have not done oral argument for quite a while, so forgive me. But let me start with the third. I do not think it bars delegation. All and the rest of the syntax of the sentence notwithstanding. I do not think it bars, and I was impressed by the literature in the law reviews that go back to the early days when there appears to have been some delegation other than fill in the blanks or fact-finding as a predicate for it, which is the basis that is being used by Justice Gorsuch. The second question that you raised is, do I think that you weren't leading question, do I think that the Constitution is fixed? Yes. I can pick it up, I can read it, it says things, I think they are critically important, but I don't think that words tell all, and I think you can interpret the Constitution while respecting it greatly. And I do respect it greatly. And so I think the third point was that you suggested that I said that the Constitution is now meaningless, and we shouldn't, you thought I said, let me try this again, you thought I said that we should almost ignore the Constitution and focus on the present. I didn't intend to say that, and to anyone else who heard that, no. I believe we should start with the Constitution, just like I believe we should start with the text of a statute. But I think that the Constitution, even as amended, reflects 2 centuries ago in a very different world. The values that it embodied are forever living in my mind, in this country. The virtues that they speak of in the Federalist Papers are the ones to which I would aspire, and I would hope that our elected officials would aspire. This is what I see for our country. Over 200 years ago, we set off on an experiment that was phenomenal And the Constitution is the basis for it, and I respect it tremendously. But we're several hundred years later, and we're facing different issues. So let us be informed by the thoughts that they had, the words that they used, and the purposes they were trying to accomplish. They did not want a situation where political parties, factions, shut down the Congress. It's not that they're incompetent. They're completely competent. They just are much more interested in who will win the next election. That's the only thing they care about. That's why they're here. They are as much a part-time legislator as they were back in 1789. Then they went back and tilled the fields. Here they go back and dial for dollars.
So do you think then, I mean, to something that Philip alluded to, I think, at the beginning, is it only, can the modern administrative state only be justified with a theory of living constitutionalism? Like, without living constitutionalism, can you have the modern administrative state?
That's a really good question, and I think I would say I'd like to think more about it, but I think you could have an administrative state without a living constitution. But then again,
Maybe
I
not.
think the Constitution lives.
Well, you know, it's interesting. I think the original progressives, the early 20th century progressives, were much more candid about the
Candid? Come on.
No, but they were very well. You are candid. Sally's nothing if not candid.
For years.
Yeah. No, but they were
Candor
very,
is one of my all-time high
that
points.
is true. That is true.
That and my
That is
hair.
true.
Right.
Absolutely. But they were very, I guess, forthright about saying that what they were trying to do in creating the modern administrative state was directly at odds with the original Constitution and its commitment to individual liberty and private property. And so they recognized that there was a serious tension. And they were okay with that because they thought the modern administrative state, that the administrative state they were creating was important. But they were very, I think, forthright in saying, this is not consistent with the Constitution. But I think today we don't talk about it that way.
Well, no, I take your point, and I think it's valid, just like these independent regulatory commissions are out there. These are these little animals that used to be, they were multi-headed, staggered terms, equal representation of the two parties based on expertise. And the idea was that they should be independent of the president because you just didn't want politics messing around with some of these matters. And there was always this debate about IRCs, independent regulatory commissions. What branch of the government are they in? Well, I personally, relying on the Constitution, see three branches. They're not in the Congress, they're not in the courts. I think they're in the executive branch. But they exist, although right now it's not clear what, after Celia Law and Collins, it's not clear that you'll have any that aren't multi-headed, but, oh God, the next one is the Social Security Administration. I love my checks. I really don't want that one to be politicized. I'm really worried about that, by the way, in case you think I'm joking.
Well, thank you. I must say that among all the possible interlocutors, I really do think that you're more engaged in good faith with the Constitution than many. And so I'm very grateful that we're able to have this conversation. And I appreciate what you say about the independent agencies, that we can agree that this is really problematic. Because many people don't care about the different parts of government, and you do. And so I think that's wonderful. Maybe you'll join us in a brief on this subject in the near future. Really, why not? Why not? On non-delegation, I this is not in the published literature yet. I have a piece called Non-Delegation Blues that's on SSRN at least. And there, I go through the textual argument, and the text doesn't matter, as we both agree, but also the living constitution argument, the principles, as it were. And I think non-delegation suffers on both accounts. It cannot be justified, the current doctrine that is. The Constitution, in its very text, locates legislative power in Congress by saying shall be vested. But it's not just text. I agree with you, one has to go beyond that. And here we get to principles in the nature of our society. Our society was founded in a revolution seeking consensual government, and not just consensual government, but representative consent. A representative in London wasn't the same thing, particularly if you don't vote for them. And we have a similar sort of problem with a distant administrative state. You may think that notice and comment cures this, but that's a very academic response. People don't feel that. So we have this division in our society that's not going to be cured with academic talk about notice and consent. We no longer have representative government for most of the laws that are made, namely the regulations that come out of agencies. And this matters especially because it's a diverse society. We have had little homogeneous societies. 18th century Connecticut, my home state, is an example. In 18th century Connecticut, although there was representative government, there was great trust amongst everyone because everyone had this belief they were all descended essentially from the same few families and everyone was interrelated. There was some truth to this, at least in the 18th century. But that's changed. Connecticut is now a very diverse society. And what happened as it became more diverse, and is true already in the early 19th century and then increasingly thereafter, is that people don't trust each other when they say, don't worry, I'll take care of your interests. Well, maybe, maybe not. And at that point, you want to vote for the people who are making the laws. You want to be involved in the lawmaking. And so I think the very nature of our society requires that we go back to our fundamental principles of representative consent. The same is true of independent judges. We need independent judges precisely so that we have folks we can trust to resolve differences. So yes, it's not the text. I think we're in agreement on that. But the very principles of our society and our exigent circumstances, I think, drive the conversation.
I'm moved by what you say and would very much like to embrace it. And I do not want to trivialize it, but I do want to note that there's a traffic light at the corner of L and Connecticut, right outside this building. The light is red, the light is green. And surely, when it turns red, it's an infringement. It can be burdensome, it can be costly if you're late for a meeting, and it certainly impairs your freedom, not to just be able to go down Connecticut Avenue. So you want it to stay green longer. How much longer? Well, that might depend on whether you're on Connecticut or on L Street, heading up to the Capitol. Now, as I say, I don't want to trivialize it, but our life is such, and this is in part an answer to Judge Rao's question, we are living in a world that is extraordinarily complicated and very complex, and we need rules. And no one who lives in the District of Columbia has much say over how long that light stays green. Of course, we have no say over anything. I live in the District of Columbia. I'm not in a state. I have no representative. Representation without taxation. Or no, it's taxation without representation. I mean, that's my problem. But
Representation without taxation would be pretty great.
but I'd give up paying. No, I wouldn't. But in all seriousness, we do not have the kind of representative government. And you talked about dilution of the vote. I have no vote whatsoever. I do have a representative in the House of Representatives, and she may speak sometimes, but she can never vote. I have to correct that. She can when it's a thing of the whole, but not otherwise. But in all seriousness, rules are not well received by anyone when they pinch, when they cost money, when they are difficult. We all would like to have free markets. We all would like to have a state in which you can do whatever you damn please. And that's understandable. But in today, I just don't think it makes much sense. And if we want clean air, which, by the way, crosses state lines, or clean water, or safe food, or civil rights, or any number of things, we need those concepts fleshed out. And that is done by the administrative state. And you don't like the administrative state very much. And I guess I'm a little fonder of the administrative state than you are. But I think we should be able to agree that at least in some places, at some times, rules make sense.
I'd also, as we continue this discussion, I'd like to invite anyone to come to the microphone if they have questions. But I think Phil,
May I just say a little bit about, I don't want to go in great length here. Yes, I agree rules make sense, but I like laws more than rules. It seems to me that if the rule is part of a law, then we're in less disagreement. You seem to be assuming, I think mistakenly, that everyone in this room is against more regulation. I can't speak for others. I'm not a libertarian. Many of my friends are libertarians, but I'm not a libertarian. I'm not against regulation. I can think of a lot of regulations I'd like to see adopted that won't be under the current regime. One of the dangers, of course, is that agencies do not control industries, but are controlled by industry, and that is a serious problem. So don't assume motivation here. DC said should have voting rights, but at least we agree on the principles of voting rights. So we're moving here. This is good. As for the traffic on Connecticut Avenue, you're right, it doesn't move, but I think it's because of too many cars, not those stoplights. There is no problem, by the way, with administrative power in municipalities. It has always been the power of municipalities. It's at the state and the federal level that one runs into constitutional problems. So there may be room for agreement here. We'll see. Thank you.
Yeah, yes. If you could just state your name and ask a question, not make statements, we'd appreciate it.
Sure, thank you so much. Gideon Rappaport. And my question is, you raised the issue of methods of interpretation as well. Justice Scalia once said that we need to interpret things reasonably, although for him reasonable is probably more strict than other people. What about judges interpreting the law honestly? Even if one method is not objectively the most correct or the most practical, isn't there an inherent value in having one that makes the judicial decision-making process transparent and gives judges the least opportunity to smuggle in their own personal preferences or to sort of collude with other branches of government, possibly with the agencies themselves, to secure certain outcomes, for example, in energy cases and pipelines, but completely opposite outcomes following the same basic procedural reasoning in other cases? Thank you.
May I take this? So I could not agree more. I devoted 8 years of my life to writing a book called Law and Judicial Duty, the gist of which is along these lines. And this was understood, by the way, in the late 18th century, not just by those on Supreme Courts, but on county courts, justices of the peace who weren't even lawyers. They all understood that they held an office in which they were accountable to God, to be truthful about the law, to do their best, however difficult, to discern the law. When they couldn't discern the law, they were to stop. Where they could discern the law, even a justice of the peace sitting on a county court, on an inferior court, was to hold the law unconstitutional without any judicial activism or any judicial restraint. Those terms have been much misunderstood in our century, but just forthrightly, candidly. I can't help thinking, I wasn't going to discuss this, but I'm glad you raised it. I held back because I think the language is too strong. But I've been thinking a lot about Solzhenitsyn's Live Not by Lies. The day he's thrown out of the Soviet Union, 1974, he publishes this little Samizdat essay, which I recommend to all of you. It's online. It takes 10 minutes to read. Live Not by Lies. Now, his circumstances were far more exigent than anything we face. And there's a very deep personal commitment, more than even most dissidents could face. That's why Václav Havel writes The Power of the Powerless, which has a much more moderate vision of resistance. But it's relevant. We cannot have a society, law, let alone a society, built on untruths. And so it's essential for judges to struggle, however difficult it is, to get the law right. And I think a lot about science and scientists. Scientists are actually brought up in a understanding of modesty. I know most scientists are immodest, but they're committed to scientific modesty, namely that they may be wrong. And so scientists struggle against their prejudices, just as judges should do. It's the same intellectual model. And they're accustomed to error, because error is what science is all about. People are always trying to prove the theory wrong. And so when there's an error, they're accustomed to saying, yes, I was wrong. Now let me try to do it better and get it right. And I wish we had judges, along the lines you suggest, who are not afraid of saying, yes, I was in error. Our Supreme Court, there's no appeal from our Supreme Court except to us. And we exercise moral and political judgment and legal judgment in judgment on their judgments. But that appeal to the people has no formal expression. But we are judging them all the time, and they have to be aware of that. We're looking for their honesty, their candor. Someone can get it wrong, but we don't want the game playing. There's no room for that. And so, yes, I hope our judges can live up to these ideals. We're in trouble if they can't. Thank you.
Let me just say, as a judge, I highly recommend Philip's book on this. No, it's really an excellent historical and very compelling account of what the judicial power entails.
And it will help you sleep well.
Okay. Another question?
Yes. Hi, Greg Dolan from the University of Baltimore. I wanted to ask a question about this notion was brought up that, look, Constitution doesn't explicitly forbid delegation, and therefore there's no warrant to prohibit it in our adjudication. And since society evolves, we need administrative state. So I guess I just wonder, how far does that logic extend? Because the Constitution also doesn't explicitly say that, look, if you can't delegate halfway, right, as we did in pre-INS v. Chadha, right? So you can delegate some, but reserve the power to to veto in Congress. So I guess the question is, does your theory then potentially call into question like INS v. Chadha, where Congress can say, look, we'll delegate some, but we'll still hold your hand in there? Or is it an all-none proposition? And if it's the latter, why only the latter? Why does it have to be all or none?
I take it that's addressed to me. Yes, thank you. And thank you for your question. It's not my theory, it was Justice Stevens' theory, but I did repeat it, and therefore I suppose I will claim some ownership from it rather than walk away from it. And I guess the answer is not all or nothing. I think there are variations in the way one can look at these kinds of things. The Constitution says some things. It doesn't address other things. That's why you have a necessary and proper clause in Article 1, Section 8. I mean, it's why you have very vague languages about take care take care clause. Yes, I know the end of it. At least I used to know the end of it. In any event, those are open-ended. And I think the Constitution, this is what I was saying earlier, embodies certain attributes that I adhere to. But I think for us to be as, if you'll forgive me, obsessed as we are about restricting the delegation based on a reading of the Constitution is overblown.
Next question.
Thank you. Alexander Evans, Baruch College. Thanks for a very interesting panel. My question is also, Professor Katzen, for you. You asked us to consider, if I understood correctly, policy considerations of revisiting the non-delegation doctrine, and I was a bit confused about the way that fit into the argument. Suppose that Actually, you're 100% right, and if we were to revisit the non-delegation doctrine and constrain the administrative state, it would be disastrous. It would just be terrible. The traffic would be awful. It would just, I wouldn't be able to get this tie. It's just that the food would get worse. Everything would be worse in every possible respect. Isn't that an argument for amending the Constitution so that the non-delegation doctrine isn't there anymore? I mean, if the law says that, even if the policy outcomes are really bad, then that's what we have to do, and the Constitution provides amendment as a recourse for bad policy. How does the policy argument fit in here? Thank you.
I think you're absolutely right. I definitely splashed in a bit of policy there. I had at first started with the text, as I thought I should, and I did go through that. I didn't think it was compelling enough to preclude. I also said that I thought that I would not persuade anyone, or at least not 6 of the current Supreme Court justices. I was not posing an argument or even a brief to the Supreme Court on this issue, although I would note that in virtually every major divisive case that lands at the Supreme Court, there's always a policy discussion. There's always the question, it used to be from Justice Scalia, there's always the question was, if we do this, then how do you distinguish that? And what would that lead to? Because it is one thing to say we're going to read the letters, and it's another to say, what are the implications of that? I did merge them, and I don't regret it. And it's quite perceptive of you to pick up that I did slip into that. But I think those who champion what I think is a very cramped view should recognize that if you prevail, be careful what you wish for. It may come about and you might be unhappy with the result.
May I join in here? One of the standard arguments against getting rid of the administrative state, or even tempering it a little bit, is that, yes, the world will fall apart, the sky will fall. Maybe. I'm not convinced. The sky doesn't fall that easily. The reality is we don't have to get rid of agencies. I've actually proposed that we should double the pay of everyone working in an agency as long as they act lawfully. And we can keep those agencies. I don't think they have as much expertise as they believe. I don't think expertise is the same as science. But we could, if you want, keep those agencies, and they can continue to propose exactly the same rules. They just should send them to Congress. If Congress is so inclined, it can enact those rules faster than they can be adopted under the APA. But Congress usually will not be so inclined, and with good reason, because then there'll be accountability to the diverse quality of our society. If our society is a hierarchical society dominated by the class that's well represented in this room, then you can leave things to agencies. You cannot do that in a fully egalitarian and diverse society. The trouble that will follow from an administrative state dictating to a diverse people is nothing any of us want. So even if you didn't believe in consensual government, even if you don't want independent judges, even if you love the administrative state, you might hesitate, you won't get what you want, right? If one's worried about the fractures in our society, you should worry about the administrative state.
Philip, if I could just ask you a question about this. If we, taking all of your points, that there's a real urgency for there to be change. I mean, do you think that the American people want that change, right? Maybe it's essential for all the reasons you say to have a more egalitarian society, to respect diversity, to have, better democratic accountability and voting rights. But do we see evidence that this is what people want?
I don't have a neat answer to that. I suspect that many people have not fully conscious of this, but actually that's part of what troubles me. You see, if people feel uncomfortable being bossed about, but they don't associate that with the administrative state or something unlawful, but rather associate it with our government as a whole, then we're really in trouble. So I hope people think this through. The danger is, as Sally mentioned, that we resent something when we feel it, when it's imposed on us. And it may be, therefore, that many people haven't thought this through sufficiently. I don't think in any society you'll always get full unanimous understanding on any policy, but I do think there's growing understanding of this. And for that, we have to thank not us in this room, but we have to thank my former colleague, Barack Obama, who went around saying, look, I can do it with a phone and a pen. Well, when you put it that brazenly, we learned. This current administration has been a good education. This regard too. But I think Republicans are often as bad as Democrats, right? When presidents like to rule from above, we begin to want governance from below. I don't know if that answers it, but.
Judge Ryle, there are data on the point that you asked about. Pew has done a lot of studies, as have others. And the two clear answers are, one, people think there are too many rules. Two, people cannot decide which rules they want to go because they love them all. And so people will say, I'm against rules, but I want clean air, I want safe food, I want this, that, and the next thing. And this has been studied again and again. And the interesting thing is that it doesn't seem to change from administration to administration. It seems to be very consistent. People don't want rules, but they don't want to get rid of any that they have.
May I just come back on this, which is that data on alienation is more sobering, right?
I'm sorry?
Data on alienation is more sobering. There is growing alienation in our society, and you don't have to be a social scientist to figure that out. And so there's a larger set of concerns here, which I don't think we can put aside.
Oh, and I completely agree with you on this, Phil, and it is very, very troubling. I worry that some of it comes from some of our leaders. Not just the I rule with the, and he didn't say I rule with, but I could use the pen and the pulpit. But we have had government bashing since Ronald Reagan, who said the government is not the solution, it's the problem. We've had people running for office who have criticized the government up one side and down the other. We have had any number of candidates and elected officials who have not only bureaucrat bashing, but even fellow political bashing. And that has led, as you say, to enormous alienation and distrust of the government. And that is extraordinarily worrisome. Right. I join you in that.
I worry about attributing too much to particular politicians. A lot of this is, I think, from a sociological point of view, inherent in a system when people have very little voice in the rules that govern them. We used to govern ourselves in small communities, and we have destroyed that through federal law, federal rules, and federal conditions. We used to know the people, therefore, who represented to us. That's a degree of connectedness that we have to allow back into the system. And so it seems to me we need to return to federalism. We need to return to lawmaking made by our representatives. And we have to distinguish between anti-government sentiment and anti-administrative sentiment. Being opposed to the government that is not ours really matters. Being opposed to the US government is another matter altogether. I pledge allegiance to the United States of America, not to the administrative state.
Okay, that was not fair. But I think this is a debate that you and I could have at another luncheon if they will sponsor us. But for now, there's still a queue.
I'd say those, I mean, Sally, in Executive Order 12866, that recognizes principles like the government shouldn't act unless there's a need, or private ordering fails, right? So you are, you're not all pro-regulation across the board either, right?
No,
Yeah.
of course not.
No.
I stand by every word that President Clinton signed.
But that document is pretty, I don't know.
Brilliant.
Well, it's brilliant, of course. But, it puts a real thumb on the scale of private ordering.
No,
At least how I read it. But
It is.
yeah.
And I don't back away from anything
Yeah.
in that. And I'm not saying, and I hope none of you walks away with the impression that I think we don't have enough rules, that we need more, double, treble, whatever. No, I'm just saying that I believe that some of the attacks on the administrative state are unfair and unfounded, and that even speaking of the administrative state is problematic, because just as there are different rules and there are different types of agencies, the administrative state is not a unitary thing. It's composed of lots of different agencies doing lots of different things. And with respect to Executive Order 12866, if you can nip it in the bud when it's first a new rule is being proposed and ensure that the benefits will justify the costs, et cetera, then I think that may well inure to the benefit of the country as a whole.
Next question.
Hi, Dan Epstein. My question is for Professor Katzen. You've mentioned a lot about, in 12866 is a great example of this, of administration or the administrative state as a rulemaking state, regulation through rules. But I think as practitioners have known for decades, and finally scholarship is catching up with this, you can see this with Rory Van Loos' work. Most regulators don't act through rules. They act through requests for information, audits, examinations, investigations, all of which are kind of sub-rule or not kind of subject to rulemaking. And so I guess my question for you is, would you say that the administrative state should not act in ways that aren't clearly established via rules, even rules of jurisdiction? Or is your view that it's a good thing that regulators can act with discretion outside of rules that govern both their authority and their jurisdiction?
That's a very interesting question. I guess I'd go with the latter. But it's not outside their jurisdiction. I think that when the IRS has a provision and it's April 14th, I'd like to be able to call somebody and get a human being on the other end of the phone and respond to a question I have. And he or she may be relying on guidance. He or she may be relying on their own interpretation of the statute. I thought you were going to go in a different direction, though. I thought you were going to say rules are only a part of it. There's also all this adjudication out there. There's formal adjudication and there's all sorts of informal adjudication. If you're talking about the administrative state, student loans, who's eligible, who isn't, disability insurance, who's eligible, who isn't, veterans benefits, who's eligible, who is. These are all things that are decided in adjudications, usually by an administrative law judge, but not necessarily. And that's part of the administrative state as well. I don't think that the rules are paramount, they're just the most visible. But for human beings living in this country, I think they're likely to run into an adjudicative issue before they run into a rulemaking issue, but that's surmise only.
Can you come in? So I think Dan's point is tremendously important. and I discussed this a little bit in my response to Adrian Vermeule years ago. The defenders of the administrative state, Adrian and thousands of others, will always retreat to rulemaking, notice and comment, and ALJs when defending it, this fairly formal, seemingly innocuous structure. But that's not the way it actually works. Most of the controls and intrusions come beneath those rules, and often in the form of extortion, in overt threats, which are sometimes very, very ugly. And so when we talk about the administrative state, there's the formal administrative state, and then there's the rather grim reality. It reminds me of Trollope's novel, at least the title, The Way We're Governed Now, is the way I would put it. ALJs are a good example of this, since you mentioned them. ALJs we're told, oh, they're neutral, they're carefully chosen by a merit board, blah, blah, blah. These are not judges. They don't operate with juries. They operate with a different burden of proof than we're accustomed to in real courts. What's more, their decisions typically are finalized or reviewable by the agency heads, which means they're always looking over their shoulder to make sure they get it right so they don't get overruled by a political body. This is a profound constitutional problem. These ALJs, however virtuous and well-meaning they may be personally, and they're not all well-meaning, as we've found out at the New Civil Liberties Alliance, but however well-meaning 99% of them may be, they structurally are incapable of decision-makings in accord with due process because they are reviewable by political bodies. And this is ugly, right? And we should have no doubts about that. And then finally, I want to get back to the early part of the conversation. OIRA serves many valuable purposes. It constrains a lot of rulemaking and nipping it in the bud. I think that's admirable. I just want to point out we have two very different visions about how to restrain power. One vision is sort of a, not quite an economist, but a econometrics vision of limiting power, that the administrative state will control itself by having economic measures of what can get through and what cannot. In the absence of other controls, it's highly desirable. So thank you. At the same time, it seems to me we have another vision of control, which are legal limits. Different spheres of authority allocated to different parts of government and between government and the people. And those legal limits are the ones that I think as lawyers we should be standing on. Thanks.
Next question.
Myron E. Bell, Competitive Enterprise Institute. I'm persuaded by the principled arguments against Chevron deference, and I understand that many people are not convinced. But I would like to ask whether you both could agree that the principal practical consequence of Chevron deference is that in at least 99 out of 100 instances, the regulator's interpretation serves to expand the regulator's authority and power over those being regulated. And it seems to me that the discussion here, the debate, is actually because people on the right don't like that, and people on the left do like that.
Yes?
No. No, I don't think it is 99.9%. The agency is winning and expanding its jurisdiction. There are, if I'm not mistaken, more Republican presidents than Democratic presidents in the last 50, 75 years. And their minions, I don't mean to be disparaging, but their people were definitely often invoking their interpretation of the law to restrict or constrain the agency's jurisdiction. And there are a number of instances where this occurs. We just had 4 years of this, if you have a memory that goes back 7 years.
If I can just be more serious for a minute, I just want to note, more serious than I was earlier, which is simply that, you know, the concern about Chevron deference is all about principle. I think many of us in this room, all of us, are dedicated to independent judiciary. It's not the robes that make a judge, right? Not sitting on the bench, What makes a judge is a certain mental stance. It's hard work, dedication to being independent of all pre-commitment. And when the Supreme Court imposes on all judges a requirement to give up one's independence and be pre-committed to the interpretation of one of the parties, it's not just about policy, and it's not just about the particular case and those defendants who lose. It corrupts the entire legal system. I don't think the Supreme Court quite understands the degree to which they have corrupted themselves. In order to make way for the administrative state, they have destroyed the judiciary's own independence. And that is fatal. By the way, the judges in the 1630s in England did this. It took them a century to recover their reputation. The judges, especially the justices of the Supreme Court, need to understand that their own reputation is at stake. They have bowed to the administrative state, and they should bow to no one.
I think we have time for one final question. Mark?
This question is for Professor Katzen. I don't think we're going to persuade you on Chevron deference, but I wonder if we might persuade you on Brand X deference. You suggested that once the courts have decided on the meaning of a statute, that's it. But as I'm sure you know, that's not really true. An administrative agency can come along behind that, reinterpret the statute with a notice and comment regulation, and then when that same issue gets back to the court under Brand X deference doesn't recur to its own prior precedent on that question. It has to take the interpretation of the administrative agency. So with the little doll there, the judge is actually bending over backwards, giving deference to the administrative agency in that context. And
you've obviously,
Judge,
yeah.
One little quick point. Judge Rao's former boss, Justice Thomas, in his...
That's what I was going to refer to.
Okay.
The Burwell decision.
Baldwin.
Baldwin decision, in which he dissented from the courts not taking a case from, I think, the Ninth Circuit, which would have enabled them to rethink Brand X ab initio. And he said, I wrote Brand X, and I disagree with it, and I think we should take it. And it was a very well-written, well-thought-through opinion by Justice Thomas on that issue. You know, when I teach Brand X, I am not unreservedly enthusiastic about it. Which is a way of, and I try to keep it straight with the students rather than wear my D jersey. But I find Brand X troubling, particularly, well, I'll just stop there. I find Brand X troubling, and it shocked me that the court didn't want to take that case. Given what they've been doing with our deference and given what I think they're going to do with Chevron deference, why didn't they take that one? And that surprised me, but I did find Justice Thomas's decision to be very interesting. Can I make a closing comment? Because I know the time is right. I took administrative law in the 1960s. It was so boring. We read FERC cases, FERC rate cases. It was horrid. I don't think administrative law is the same today. I think it's pretty exciting, pretty interesting, and I thank you all for at least listening to some of my thoughts.
Well, I'd just like to say, I think in Washington we are very lucky to have had such a erudite, engaging, and congenial discussion on this topic. So if you could please join me in thanking our panelists.
I'm retired, actually. I did 36 years in government.